Hello and welcome to the Legal Concierge podcast, hosted by Warner Lewis. Warner addresses a wide range of legal questions, situations, and solutions that may apply to you. The information provided in this podcast is for educational purposes only and is not a substitute for legal, financial, or accounting advice of any kind. Warner Lewis is an experienced, trusted resource whose mission is to help you find the answers you need when you're not sure who to turn to. Warner can refer you to a competent lawyer in your area of concern if appropriate. Chat with Warner live every Tuesday on YouTube or Facebook. And now, Warner Lewis, the Legal Concierge.
Hello and welcome back to the Legal Concierge. This is episode 7 of the podcast. Very excited to have made it this far and hope to go another 700. That would be terrific. First, right off the bat, thanks to my producers, Toby and Shelley. You all do a great job and appreciate it. We'll get you on this program to promote your services here in the next week or several weeks soon, and let everybody know how you might be able to help them get their podcasts up and running, because you guys do a great job. So thanks so much. So again, welcome to the Legal Concierge podcast. My name is Warner Lewis. I'm the CEO and founder of Life Planning, Inc., an Arizona certified legal document preparer. We're authorized by the Supreme Court of our state to provide legal information and legal document preparation services for any consumer anywhere in the United States. There's no restriction as to our geographic reach. So that's the the life planning business. We do estate planning, wills, trusts, powers of attorney, business planning, LLCs, corporations, and whatnot. So if you have any needs in those areas, let us know. We'll give you contact information shortly and make it easy for you to arrange and schedule a no cost, no obligation consultation on the legal document preparation side or the attorney referral side. Now, the attorney referrals are provided through the Legal Concierge, where we're a matchmaker essentially between individuals and businesses' legal needs and the right lawyer. In other words, the lawyer who's most skilled and best prepared, best equipped to help you in that particular matter. And we strive to bring that engagement to you on a fixed fee basis. Now, the Legal Concierge service costs you nothing. So anyway, if you have a legal need that goes beyond the estate planning and business planning, let us know and we'll match you with the right professional. Okay, great. Thank you again for joining us. So today's topic is the sandwich generation. This is actually, Toby, if you'd go full, then please like, share, and subscribe. It would really help us if you were to take just a moment, go into the information box and like what we're doing, and then subscribe. We promise we won't bombard you or bug you at all. Just the more subscribers we have, the better. So if you'll just take a moment now to do that, we'd sure appreciate it. Thanks so much. So today's topic is the sandwich generation, challenges and opportunities that we as the sandwich generation face. Now, what is the sandwich generation? Who are we? Let me get my PowerPoint going. Here we go. So the sandwich generation the definition of the sandwich generation is if you have children and if you have living parents. You are the middle of that sandwich where you have concerns with respect to your children and providing for them, as well as making sure that your parents' planning efforts don't backfire and blow up in your face as the one who maybe is named, or if there are no documents, then you have to seek assistance, for probate and things like that to become appointed for your parents. So we'll talk in more detail about both sides of the sandwich as well as the middle. That's you. So stay tuned. So here are your challenges as a parent of children and as the children of your parents. So first of all, we all face this one human condition, a terminal condition, and we all have it. Nobody gets out alive. Life is a terminal condition. So we have to think about what happens when we become incapacitated or pass away, and when our parents become incapacitated or pass away. So that's the biggest challenge, is that life is terminal and we get to deal with it one way or the other, either prepared, well prepared, or ill prepared. And there's a big difference in the outcome. So the other fundamental truth is that you own stuff. stuff belongs to you, your house, my phone. Let me turn off my phone for just a second. You own stuff. You own your house. You own cars. You own bank accounts, perhaps investments, and IRAs and that sort of thing. One moment, please. Forgive me. I'm sorry. I'm going to do this. Just give me a sec, okay? Thanks very much. I appreciate it. Don't want this to bother us again today. All right, all set. Terrific. So you own assets. And the way you own assets, the way they're titled to you, make a huge difference. So you either own them solo in just your name as joint tenants with someone else, or if you're in a community property state, you would own marital community property as community property, okay? And then the ROS stands for rights of survivorship. So you can own assets in joint tenancy or community property, but forget to check the rights of survivorship box, which causes a whole new set of problems, because at the first death, if it's just joint tenants or just community property, the other owner who's now deceased took ownership of their half of your asset, your house, your bank account, your brokerage account, with them to the grave. And then this happened more 25, 30 years ago, when rights of survivorship didn't really exist or wasn't well known, wasn't well taken advantage of by people, to avoid probating the first spouse to die, their ownership interest in your jointly owned property. So if that sounds a little complicated, I understand. Go ahead and give me a call, and I'll be happy to, or schedule some time, and we'll show you how to do that here in a moment. And we'll talk through it, okay? But how you own your property will have a huge impact on what happens to your property and how it gets passed to your loved ones upon your incapacity or your death. Now, if you die owning property in your own name, your estate, whatever is stuck in your name when you die, does not have a joint tenant with rights of survivorship who inherits it automatically upon your death. So let's say, for example, you as husband and wife own property as joint tenants with rights of survivorship, or community property with rights of survivorship. The first one of you dies, the survivor of you inherits it 100%, lock, stock, and barrel. But at the second death, the survivor, upon their death, if they don't take action, it will likely be stuck in their name when they die, and their heirs and their children, their loved ones, will have to probate ownership of the house, whatever's stuck in your name, through the probate process, which is lengthy and costly. So just know that we have all of these topics already well addressed in previous Legal Concierge podcasts up on our YouTube channel. So you can go to YouTube and search the Legal Concierge, and you'll see our logo and all of that. You'll see this, my face, and you can check out the different topics that we touch on here, but I'm not going to go into them in depth today. One big solution that one can deploy in order to avoid probate and protect assets, deal with living trusts and LLCs. These are also addressed in great detail on our YouTube channel. So rather than go into those now, I really want to focus on your challenges as the sandwich generation, but you can find answers to all your questions up on YouTube anytime. So your challenges include your children, your parents, and your relatives. Okay, your children, if they are minors, that's one set of problems. If they're 18 or older, in other words, they're of majority age, that's another set of problems, and we'll talk about those in more detail. Your parents, depending on their stage of life, they're either healthy and vibrant and vital, and I hope that for all of our parents. I wish that for all of our parents. But as life progresses, life progresses, and as we age, obviously, we often lose perhaps the cognitive capabilities that we once had. And so these are situations that we'll address here momentarily. And our relatives too, right? Your brothers, sisters, nieces, nephews, aunts and uncles, cousins. These are all people who may at some point have a role to play in your estate planning. So it's very important to sit with a competent estate planner and let them help you think through all of the possible outcomes and permutations based on your situation, and address each and every one of them in an effective way. Okay, so these are your challenges. You have some planning to do. Now, if you have questions about this initial segment of the show, go ahead and feel free to call the office. This is the local number in Scottsdale, Arizona, and the toll-free number from anywhere in the United States. You can also jump directly onto my calendar by going to calendly.com/Warner-1 and schedule 15 minutes if it's just a quick chat, 30 minutes if we need more time. And then typically once clients, we answer those initial questions, the initial part of the process for engaging us and getting going in the planning process, that's usually a 60 to a 90-minute meeting. So you could shoot for 15 minutes for quick questions and answers, or 30 minutes for more in-depth. Feel free to do that. And then of course you can email me your circumstances and your questions to warner@legal-concierge.net. Okay, great, super. So here are some challenges with your children that you may face with children. So first of all, if they're minors, if they're under the age of 18, then you have issues including guardianship. In other words, if something happens to you as the parent or the parents, who will you give legal rights or legal standing to raise your children? And then the power of attorney could be the same people as the guardians that you appoint, but the power of attorney gives the people that you trust legal standing to make financial and medical decisions for your minor children. Now, once your children become of majority age, they're 18, but then one big question is, are they of sufficient age and maturity to make their own decisions? And this is especially important if you name a child as a beneficiary of a trust, for example. You may not want them to get it at the age of 18 because they may be faced with a dilemma. And that dilemma could look something like, gee, do I pursue a college education or do I really want that red Ferrari? So these are the things that we need to think about and that we can control in the right documents, the living trust and the powers of attorney and all of that. So that's one big question. Are your children of sufficient age and maturity? Also, did you know that once your child turns 18, if they were to become incapacitated, you do not have the legal right to make decisions for them, either financial decisions or medical decisions, because they're of majority age. They're no longer your minor children. So many people, more and more people, as their children go off to college, are putting together powers of attorney for their own children who are 18, appointing mom and dad as being able to make financial and healthcare documents. But without those documents, you'd have to go to court and get a judge to approve you. It's just a technicality, but it's a pain. And we can preempt that pain by putting these powers of attorney into effect. And then you have to think about, once you pass, how your children will inherit from you. Do they inherit through a will, which requires probate? Go back up to YouTube and check out the wills versus trust conversation up there. We won't go into that now, but if you have no plan in place or just a will, just know that it's going through probate for the most part. Now, you can avoid probate through POD, pay on death beneficiary designations, but we lose the protection that you could otherwise have with better planning or a higher level of planning. Because if a child inherits an account from you, say, through a pay on death, POD, or transfer on death, TOD, beneficiary designation, they receive it in their own name. But if they get into an accident, get sued, a judgment, or a divorce, because that money is in their name, it can be taken from them. And we can do a much better job than that with the right documentation to protect these assets for future generations, to keep that money out of the reach of your children's predators. In other words, creditors, judgments, lawsuits, and divorces. So any questions about this, feel free to give us a call, toll free if you choose, schedule with me on the calendar, or email me at warner@legalconcierge.net, and we'll get a conversation going, okay? And while we're at it, please do like, share, and subscribe. And we have a question, but please just take a moment now, go into the information box below and click that subscribe button. That would be really, really appreciated. Thanks so much. Does guardianship supersede a power of attorney? So guardianship is different than a power of attorney. Now, guardianship typically includes the power to make financial and medical decisions for the child, for the minor child. The power of attorney is really useful while the parents are still alive, But if something happened to the parents and all of a suddenly, there was a need for an individual who was empowered legally to make decisions for the children that they left behind, then that's when the power of attorney can come into effect, great force and effect. So guardianship covers everything, if I'm not mistaken, and the power of attorney is just for that middle period, should something happen to both parents and a child needs caring for and legal decisions to be made for them. Great question. Thank you very much. So here are the challenges that we, as the middle part of the sandwich generation, we who have children and who have parents, the challenges that we face with our parents. So life goes on, right? Time marches on, and eventually we become seniors and we come of age. Our senior years can be among our best. And I know many stories of seniors having the times of their lives, right? Falling in love and traveling and having all kinds of lots and lots of fun. But this is a very delicate life stage because it's perhaps the last quarter of our lifetimes, the last third or the last quarter of our lifetimes. And it's a pretty significant life stage where, and I don't wish this on anyone, but sometimes medical issues come up, issues of cognitive ability or impairment that need to be addressed. These are difficult decisions and situations to discuss with our parents. So we understand that there are many different life stages, and as our parents age, it's a very significant one that we really need to focus on. So the health of our parents, their current health could be great, and I know people who are cognitively sharp as a tack at 97. So again, we don't all go down the path of dementia or Alzheimer's, but we need to consider it, how our parents are currently in terms of their health. Do they have long-term care insurance? Do they have insurance of any kind? And then we need to look down the road to the future to make sure that their health needs are met. And there are lots of ways that we can help with that too. So if you have questions about that, contact us. Wealth is the other side of the equation. As our parents age, we need to consider the type of assets that they own. They might own a house. They might own a bank account. They might own individual retirement accounts or 401ks. I refer to all of those retirement plan vehicles as IRAs, but they may have IRAs. They may have a home here and perhaps a home somewhere else. If it's in the same state, no problem. If it's in a different state and we don't do proper planning, then it's possible that you could have a probate required in the state of primary residence and another probate, a parallel probate, going on in another state where parents own assets, bank accounts, homes, that sort of thing. And then the size of the estate, of course, will have a big impact on the outcome because, again, a child inheriting a large sum of money at an early age can be counterproductive, can be harmful, actually. So these are the types of issues that we need to address. And so essentially you, as the middle of the sandwich, in the sandwich generation, you want to make sure that your parents' planning is done correctly, perhaps having wills and trusts and powers of attorney in place that name you and others that they trust to make those important financial decisions in the event of incapacity or death. Now, I mention incapacity because 60% of us statistically go through some form of incapacity requiring some kind of long-term care before we pass away. The other 40% will just live their lives and then pass one day. So it's important that we put these documents in place to make sure that we know who's going to manage everything, how they're going to manage it and distribute it, and how the beneficiaries will receive it, and then when they will receive it. Again, the 18-year-old, you probably don't want an 18-year-old to inherit hundreds of thousands or millions of dollars because it's too early. We can, through these documents, make sure that money is held in further trust for the benefit of the children, so that when they attain, say, age 25, they've gotten through college, they've learned the value of a dollar by getting jobs and working. And so we can say 25 might be the first age of distribution. We could say 30 would be the second age of distribution. But these are all things that we can custom tailor to your particular and unique circumstances, because not every child is the same, not every family is the same. It's very important. One size does not fit all in the life planning arena. So just keep that in mind. So any questions about this, feel free to contact us. I'll leave this up for a few moments. Please do like, share, and subscribe. We promise the subscribing is really the cool thing. It really helps us to build the channel, and that's really the goal, is to get this information out to as many people as possible. So if you just take a moment to subscribe, hit the subscribe button, that'll help us get to more and more people. All right, thank you very much. Now let's talk about opportunities, because we've talked about all the challenges that you may well face as the middle of the sandwich, where you have children that you need to provide for and think about, many different moving parts, whether they're minors or majority age, and your parents as they progress through the years and their needs and circumstances change, sometimes drastically and sometimes very, very quickly. Unfortunately, many times we wait too long, and we have to plan while we can, because when we can no longer do it, we're no longer at mental or physical capacity to sign documents, then it's too late. So that's a whole other set of circumstances that we want to avoid. And here are the opportunities. Basically, proper planning is the key to put these documents, the wills, the trusts, the powers of attorney, in place, so that if one becomes incapacitated or one does pass, that everything is prearranged. And this is really, truly the most loving thing that we as parents can do for our children. And that's to plan in advance. And I mean, right down to funeral or burial or cremation instructions as well. This is something that, mom and dad die, and we've got 3 days, we've got to go to the mortuary, and it's just on top of everything else. That's one of the biggest things that you can do for your loved ones on your way out, would be to make your cremation or your burial planning too. I just wanted to prompt that in your memory. I know it's kind of a weird idea to go shopping for caskets or for cremation and urns, right? But it's just part of the proper planning process, right? So with parents, as the middle of the sandwich generation sandwich, we have the challenge and the opportunity of having the conversation with our parents. Mom, dad, you're moving up in years, you're doing great, but at some point, we're going to need to have a clear idea of what your wishes are in terms of cremation, burial, who you want to make medical and financial decisions for you, who you want to manage the trust that controls your assets, who you want to receive it, how and when you want them to receive it. These kinds of things that can best be accomplished through wills, trusts, powers of attorney, medical directives, etc. So having that conversation, I mean, how many of us are reluctant to have that conversation because we feel that our parents want to hold those things privately and close to the vest? So that's certainly understandable, right? Nobody wants to talk about death and dying, but it's one of our biggest challenges and opportunities, is addressing our parents in that conversation. And so we make it a family affair, right? All of the children come alongside, maybe the grandchildren too. Let's leave it to the children, and have that serious heart-to-heart, one-on-one conversation. Mom, dad, what are your wishes in this circumstance? What would you like to happen in the other circumstance? And if once they start to think about it, then it makes it easier for them to consider putting it on paper. Because if it's not in writing, it's not going to happen. You really don't want to be caught dead or incapacitated without the right documents in place. And that's the truth. And it won't affect them. It won't affect your parents, but will have a huge impact on you, their adult children. So we're all sort of selfishly motivated, not for the money, but for the ease of managing the process should mom or dad become incapacitated or pass away. So we can help with all that, of course. And then a reminder that with your children, you can establish guardianship in your wills and provide for the management of the wealth that they are going to receive in trusts. The guardianship is always, that appointment is always made in a will, because it assumes that a judge is required to supervise the guardians of minor children, right? Where the guardians go and make an accounting and they report to the judge periodically how the child is doing and how they, as the guardians, are doing. And if the guardian's not taking good care of the minor children, then the judge in theory could remove them, and perhaps the next guardians on the list would be appointed. Or if that's not possible, then the judge, the court, would appoint who the guardian of your child or your children are, your minor children. So this is something you can tell. You don't want a stranger to be appointed, like a fiduciary, be given the checkbook and the legal power to make financial and medical decisions for your child. You want to do that in advance knowingly, consciously, on purpose, with your desired individuals managing those roles. So and there's the opportunity. And then, of course, don't forget yourself. You have assets, you have children, you have retirement plan monies, you have assets, you have stuff. And so you're going to want to make sure that you get your planning done too. Again, it's the most important and loving thing you can do for your family on the way out. Okay, so don't forget that. And let us know how we can help. If you have questions, comments, concerns, any way we can help, a free consultation. So no cost and no obligation for any initial consultation. We'll be happy to. We'll talk more about that in a moment. But please contact us. Jump on my calendar. Feel free to schedule 15 or 30 minutes. Delighted to chat with you anytime. But we have to schedule it. Okay. So should you choose to get started after we have that initial conversation, or even during this initial conversation, oftentimes.
You have a couple of questions.
Oh, good. Okay. So here's a question from Sage Legion. How do you talk to your parents about estate planning? Great question. Mom, Dad, you know we love you, and we care about you, and we want to be able to care well for you should you need us to step in alongside, okay, to make medical decisions for you, to make financial decisions for you, or even at some because of incapacity or a medical condition or something like that, or you're just having such a good time in life in your 80s and you want to go around the world and travel and do things like that. You can appoint us, your children, your loved ones, the people whom you know, love, and adore you and would do anything to take care of you. You can appoint us to take care of your affairs, either with you, alongside you as a co-trustee, or at some point, some parents just relinquish trusteeship altogether to their children voluntarily. The next step then would be involuntary appointment of your successors and your agents. And we do that either through the court if you don't have the documentation, or through your powers of attorney. But having that conversation, just be, conscious, open, caring, loving. Sometimes our parents get a little paranoid as they advance through the different stages of cognitive impairment, and sometimes get very paranoid. So the earlier we can do this conversation, have this conversation, the better. And, we often meet with children and their parents and help to facilitate the conversation. So don't hesitate to consider using life planning or someone like us who's competent in this area of planning of law to kick off that conversation. This afternoon, I've got an older couple coming in with their son who's cared enough to go ahead and arrange that meeting and sit us all down at the table and begin a conversation, because the parents aren't quite sure. They're not quite sure what all this means. And we're really pretty good at helping people at whatever stage of life they may be understand what their options are and why they would want to do this kind of planning. So if you choose to get started down the planning road, schedule a no cost, no obligation consultation. We'll review all of your existing documents. So if you have wills, trusts, powers of attorney, LLCs, corporations, any of those kinds of legal documents, we'll review them all, answer all of your questions, provide you with enough legal information around what you have or don't have, and what you may want to have in the future, what you may want to put into place, either amending an existing trust, updating an existing LLC. We can help with that, but we'll give you enough legal information to make fully informed decisions for yourself as to whether that's appropriate for you. And we won't let you make a mistake, okay? And then if you choose to engage us, because remember, everything above this line is completely at no charge and no obligation, but if you do choose to engage us to help you put these legal documents in order, we'll create documents that accurately reflect your goals, your wants, your needs, your circumstances. So this is not a one-size-fits-all circumstance. I hope you get that sense from our conversation here. Everybody's different, and there is no one-size-fits-all. Like, I would not do a do-it-yourself kind of software program, because they're designed to be lowest common denominator. I don't know about you, but I'm not lowest common denominator. I have needs, I have unusual circumstances, I bet you do too, that need to be addressed. And some of these software programs just come right out and say, look, we're not guaranteeing that these are sufficient for your purpose or suitable for your purposes. We make no guarantees, and you use these documents at your own risk. Okay, that's often what you'll get on a do-it-yourself online solution or something like that. So buyer beware. Okay. And then the other thing I want to talking about buyer beware, only 3% of attorneys are competent in this area of the law: wills, trusts, powers of attorney, LLCs, corporations, asset protection planning. 3% out of 1,500,000 attorneys across the country, less than 60,000 of them are competent. But 30 million people need help in this area. The top third of asset owners need help, don't know who to turn to. So we've been the good guys for a long time, been receiving referrals from financial institutions, broker dealers, financial advisors, accountants, and other trusted intermediaries for 27 years. So we're the good guys. Anyway, then the next step, once we create the documents that accurately reflect your circumstances, your unique circumstances, we coordinate the signing of the documents, and that can be either in my office if you're in Arizona, or we can arrange for a notary to show up at your location anytime, anywhere, to provide notarization of your signatures and of your witnesses' signatures. So we do this by remote a lot. And that's a system that we streamlined quite nicely. But one way or the other, we coordinate the signing of the documents. And then the most important step is implementing your estate plan properly. In other words, if you just create a trust, but you don't transfer your home via deed into the trust, and that home is still stuck in your name when you die, then you haven't accomplished anything, because the trust can only avoid probate on the assets that it controls. So it's so important, once the trust is in place, to make sure that deed, and we provide the deeds, of course, do all that work to make sure that the house or houses are in the trust, that your LLCs and corporations, that your shares and your ownership interests are owned by your trust. Only the assets you own that are titled in the name of the trust can avoid probate. Any asset that you own that's stuck in your name is going to require some form of legal or court intervention that can be avoided easily by proper planning. So implementing your trust is so important. Get the house in, walk into the bank with your certification of trust, and let the bank change ownership of your account from you, or you and your spouse if you're married, to you as trustees of your trust. Or if they require that you close that personal account for some reason and force you to create a new account in the name of the trust, don't do that, because typically we have automatic deposits, automatic payments that come through that account, and you don't want to mess that up. You don't want to have to do that over again. So you can leave accounts in your name for the rest of your lives, but you attach, while you're alive and while you can, you attach to that account a POD, a pay on death beneficiary designation, or a TOD, transfer on death beneficiary designation, so that when you pass, they present your death certificate to the bank or the brokerage firm, and automatically ownership of that account transfers over into your trust. So you've avoided probate either way. And so if you have questions about funding your trust or the proper implementation of your trust, please feel free to give us a call. Happy to help you. So again, reach out, give us a call, jump onto my calendar, or send me an email with your comments, your questions, your concerns. SmartBeat asks a question. Is there a legal guardianship for adults with disability? Again, I'm not a lawyer. I don't give legal advice. Guardianship is not my area of competence. I would always refer guardianship issues to a competent attorney. And we have these relationships with law firms all across the country as the legal concierge, where we can match your unique. Can you put that last question back up, please, regarding incapacity? Because I really want to stay focused on that for a second. We can direct you, introduce you to the right lawyer for these kinds of much more complex questions. So yes, there can be legal guardianship for adults with disabilities who do not have the power of attorney in place. So the power of attorney handles that in advance. If one becomes incapacitated without the right documents in place, in other words, without the financial or the healthcare power of attorney, then a court typically gets involved and appoints someone, either a family member, hopefully, a trustworthy family member, hopefully, or if not, then a stranger. It could be a fiduciary or someone else, and they hand them the checkbook and the legal power to take care of your finances. And I can tell you stories where that did not work out very well, where the guardian and the lawyers representing the incapacitated person spent down $1 million+ for a woman here in Phoenix not too long ago, Lori Roberts, the Arizona Republic reporter, reported extensively on this woman's plight. It was awful, really, really terrible. They spent all her money, and then when all her money was gone, they handed the keys back to the court and said, "We can't help this person anymore. She's indigent." They didn't even carve out enough money for her to repair her teeth. I mean, this is a really bad circumstance. They're not all like that, but that just illustrates how badly it can turn out if we don't plan in advance where a stranger is appointed to make those important legal decisions for you. So you don't live in Arizona. Can you help with estate planning for your elderly parents? Yes, sure can. As I mentioned, I have clients in 34 states and ultimately all 50 states through our correspondence with law firms and others throughout the country. So yes, I can certainly help with elderly parents in states other than Arizona. So contact us. Jump on my calendar, okay? That would be great. Happy to help. Any other questions that I can help to answer? Because I think we're probably pretty close to being at the end of our podcast today. I hope this has been really helpful to you. And I encourage you, whenever you hear this message, whenever you see this podcast, to think about your own situation. And if it would be helpful for you to have a no cost, no obligation consultation, feel free. Don't be shy. And then while we're at it, go ahead and like, share, and subscribe to this podcast. Please, just as a favor to me, I would really appreciate it. We're not going to bug you, but it will really help the Legal Concierge podcast to get out to a broader audience and to help more and more people. Okay. Thank you. Blessings to you. Trust your life is going well. Merry Christmas. Not quite sure if we're going to do a podcast next week. I don't think so. No, we're not going to do it on Tuesday or Wednesday before Christmas. So Merry Christmas to you all. We probably will not do one either through the Christmas to New Year's. So we'll see you again bright, fresh, and shiny in 2022. And we'll kick off a new season of the Legal Concierge podcast. Blessings to you all. Bye-bye.
Thank you for joining the Legal Concierge podcast, hosted by Warner Lewis. Kindly hit the subscribe button below and leave a comment or question regarding your particular legal situation. Feel free to submit ideas for future shows as well. We appreciate your sharing this podcast with family and friends so they can find answers and solutions to their legal situation as well. Check the notes below for links to valuable resources. See you again next week.